Today we talk about intellectual property monetization of data and software created at universities. So data is not an intellectual property. A data point is a fact, and data is often not protectable as an IP, but can be valuable. So how do you benefit from the proprietary datasets or the trade secrets that you have in these data points? You can license them as trade secret, but it's difficult in academic setting because it's the nature of publications and student access who can then share that information wherever they go into graduate school. You can license copyright as a bundle of rights, and the right can include the ability to reproduce, to distribute, to display, to modify, or perform. Each right can be separately licensed. Copyright rights spring into being when they are created. You can officially register them as copyrights, but when by doing so, you publicly disclose them, and it becomes a part of the Library of Congress. The registration is required if you need to bring in infringement lawsuits, or you can claim damages. So, if you're licensing software, you should consider the benefits and the risks of registering. One way to minimize the disclosure is to provide just the first 15 pages or the last 15 pages of the code. And so there are techniques to reduce the amount of disclosure in getting a copyright. Let's talk about licensing models. You certainly can have a paper license that the user agrees by signing either in a wet ink or as a PDF. There's also click-through agreement where the user agrees by taking some acts, and there's also browse wrap type of agreement where the user agrees just by accessing the code. In the software license, you need to include the end user license agreement, the terms of the service, and the terms of use. In terms of software licensing, there are also considerations for open source licensing. And when you go down this path, you need to consider copyleft versus open software. What is the goal with your software asset? Is it branding recognition or is it monetization? Software licensing can also be hybrid, so you can combine open source licenses and proprietary licenses. As an example of that, let's say if you look at the AI licenses in the Llama license, it is open source up to a certain point of, let's say, I think 500,000 users, and in that scenario, if you go beyond that, you need to have an explicit agreement with Meta. So you can have certain uses for open source only and certain uses subject to proprietary licenses in that case. Let's look at the distribution models of the software. You can have an app platform, you can have website distributions, the software can be pulled through FTP feeds or directly at the platform. Alternatively, you can have a software as a service as a licensing alternative, and many universities have been doing the software as a service where they put the service onto a server. The software doesn't get distributed, it remains hosted by the licensing organization, the licensor i.e., and you can access that service via the internet. And the service is not a product. So issues that you need to pay attention to when you get your software disclosure, including diligence, i.e. you need to check who's the author and who owns it. You also need to check your institutional policies and any funding restrictions on monetizing the software. Open source restriction. They may restrict what you can do with your software. If your software is based on other third-party open source, then you need to check to see if you're obligated to disclose the source code if it's building on top of somebody else's open source code. In setting the license fees, part of that licensing cost might be considering the cost of development, the time to develop, the cost of the replacement, the cost of replications, and comparable licensing agreements. And these parameters can help you establish how to charge for the software. If you have any questions, feel free to reach out to us at Patent PC. We're here to help you. Thank you.